We have formed a quorum in the appointed time. Thank you for coming to the meeting today. Item 1, we have to deal first with the application for lay membership by Mr. Dennis Kwok and Mr. Jeremy Tam. The relevant papers have been sent to members. So I would like to seek your views as to whether you agree to their application. Yes, no objection. The more people, the merrier, right? Okay, so we passed that. We've got 2 new members then. And item 2, meeting with deputations, receiving views from deputations. So can we now first invite the 16 deputations and individuals in, please? The deputations should be filing in, right? First of all, let me tell members here, after the last meeting, the government departments and our assistant legal advisor have, in relation to the issues raised by members, have given us some written responses. And the papers are CB 22174/1617(01) and 02. So members, please note these papers. Welcome, deputations and individuals. After you are seated now, let me remind you that you have an earpiece in front of you and a loudspeaker, and you can choose the appropriate language channel. 0 is floor, 1 is Cantonese, 2 is English, and 3 is Putonghua Mandarin. And also, please note that every deputation will be given 3 minutes to speak, so please make the most use of your time. If you have not given us your written submission, please, after the meeting, submit your written submission to us. And also, your speeches will not be entitled to the protection under the Electoral Powers and Privileges Ordinance. So that means that you have to be responsible for what you speak, and also the same applies to the your written submission. They are not protected. And also in front of you, there is this note to remind members who are attending, members of the public attending the meeting. Please read through it. Now I would like to invite the deputations to speak one by one. First is Mr. An Man-ho. Thank you, Chairman. As we all know, Hong Kong has a lot of families which employ FDH, but then there is a difference in the level of quality of service provided by EA's employment agencies. And we welcome, the DAB welcomes the amendment to regulate further the EAs. We have several recommendations to make. First, in terms of the amendment direction, the penalty for EAs will be enhanced. The scope of the offences will also be expanded. DAB agrees that enhancing the penalty will cut down on illegal acts. At the same time, the government should introduce multiple forms of penalties. For example, imposing a fine, asking the EAs to undergo training, and also various other measures. In recent years, we have received complaints about overcharging, and also the description doesn't match the actual migrant workers. But then the LD has been taking out a few prosecutions because the manpower is limited and the investigation effectiveness is cast in doubt. So that's why we are asking the LD to commit more resources to the EAA Employment Agencies Administration so that they can step up their enforcement work. At the same time, Customs should also collect more intelligence on EA's malpractices, and also in relation to breaches under the Trade Description Ordinance, prosecution should be stepped up. DAB also suggests that there should be a registry of EAs to be set up so that malpractices can be cracked down properly. And the LD should also study whether probation period should be set up so that the employers can dismiss employees or domestic workers during the probation period. The Code of Practice was launched in January this year, and DAB believes that the policy objective should be set up for the COP, and a review should be conducted on the effectiveness of the COP. If the COP has proved to be ineffective, the government should step up legislation to crack down on malpractices.
Mr. Tam Ka-chun. Mr. Chair, I think in this day in Hong Kong, having foreign domestic helper is not rare indeed, and there are a few reasons for this. First of all, the government does not have very good childcare and old age care services, and no standard hour of work, and therefore we have a lot of foreign domestic helpers in Hong Kong. It's simple. And there are 350,000 helpers serving in 11% of the families in Hong Kong. But these are not slaves. They should not be exploited, these foreign domestic helpers. But the Hong Kong government had been criticized by the international arena all along for this. Now, in the June report for the employment report, it's criticized Hong Kong as not being able to live up to the standards of import of or legal import of labor. And there is a reason, because these agents are overcharging, and secondly, they are retaining the passports of the foreign domestic helpers. And research shows, even though there are regulations and laws, but malpracticing agencies actually charge 26 times over the charging limit. And this is exactly a trading of manpower, trading of persons. And we would want to see that there are more deterrent powers with the ordinance. Now, in the past 3 years of the Labor Department, 3,000 cases, only 12 of them were brought to the proceedings, and only 10 were upheld, and 5 of them were about overcharging or retention of passports by agents. And we are concerned about the enforcement of the Labor Department. And another issue is about the time limit to lodging claims. A lot of the cases will have to be concluded for the entire process within 6 months, and this is a loophole in the ordinance. We fear that some malpracticing agencies may exceed that time of 6 months. And our party has a suggestion for the government. Look at the 2015 modern labour ordinance in the UK, and which carries criminalisation. And employment agencies should be given a marking scheme so that we know which are the malpracticing ones. And also the agents in retention of passports should be prosecuted as committing theft. And also perhaps the foreign domestic helpers should find their own employers without having to go through the agencies. Ms. Lehman. Thank you, Chair. Justice Centre Hong Kong Representative Lehman. Thank you very much for coming to the meeting. And we are concerned about human trafficking. And we are concerned about the code of practice because it is related to human trafficking, in particular about overcharging of agencies. From experience of the civic organizations, often this is related to the domestic helpers having borrowed money. And where the borrowing is heavy, there may be forced labor to the tune of 6 times over the normal. We also see that within the code, the LD had already said that the agencies should not be involved in the financing or debt situation of the foreign workers. But on the other hand, if there is any violation in this, would the government investigate these cases? Would the government investigate whether they are overcharging? Because overcharging is a criminal offense. And if there are loan sharks providing finance to foreign workers, the government should also investigate whether the agencies are involved and whether they are resultant overcharging. Now, for the ordinance, would it also the trade representation, the trade description ordinance, does it also protect this regard? Now, in the ordinance, it only mentions that the employers can protect themselves. Now, if the trade description ordinance does not protect the employees, perhaps this loophole can be plugged, because this is about deception in the human trafficking offense. And in our survey, we see that 14% of the foreign domestic helpers surveyed after coming to Hong Kong, they find that the working conditions actually worse off than what was described to them before they came. So there is deception involved. Also, if this draft is to be passed, the overcharging or mischarging of fees and also operating without license. These two offences, would they continue to be summary offence, or would they be indictable offences? And also this 6-month limitation, will it still apply, please? Mr. Kwok Wan-kin. Greetings. In the past 5 years, for mischarging or overcharging cases and complaints have been increasing, 44 and in 2015 and 529 in 2016. A lot of the helpers who come to Hong Kong actually do not know of their justifiable rights. And from December to June of this year, with a survey interviewing Filipina helpers on overcharging by agencies, we found that 70% or over of the surveyed were charged over 10,000 Hong Kong dollars in terms of commission, which already exceeded the by 26 times the what is admissible. And also the employment ordinance and also the EAR had increased the penalties involved with this kind of offense, and that is correct. But on the other hand, there should be more enforcement. First of all, there should be more regulations and relevant measures to uphold the enforcement. For example, after the contract has ended, these helpers can only stay in Hong Kong for 14 days. If they cannot find a new employer, they'll have to go back to their own country. And every time they exit Hong Kong, they are squeezed by the agencies to pay up again. And these foreign domestic helpers, as a result, are afraid of lodging complaints. And therefore, they fear bringing cases to the light, to the authorities and the Labour Department in a very passive position as a result. And also for these FDH, even with the code of practice, but it does not support the helpers in lodging their complaints, and also for black market helpers. The government should be more proactive in collecting data concerning and also evidence concerning illegal activities. This 2-week stay limit is also a problem in making it difficult for the helpers to lodge complaints, and therefore there are so few cases with the LD. The manpower is also highly limited at the Labour Department, and they are at the EAA of the Labour Department, and we see that the agencies related to foreign employment exceed 1,300. And these few officers at the EAA, is it really sufficient? If not, how are they able to enforce the ordinance? That definitely the LDEAA had to be increased in terms of its manpower. Ms. Cheung, please. Yes. For most of the elderly care homes, my association actually represents the workers, or many of the workers in these homes. And we meet with a lot of problems concerning local workers. A lot of these elderly homes are served by agencies which supply local workers to these homes. And these workers are false self-employed persons. They are actually under the control of the agencies. If they do not report to work, if they take sick leave, they will have to notify the agency, otherwise they will be penalized. And where there is work-related injury, there is no compensation. The agency says that that's because they're self-employed persons. If they want to terminate their work and leave their position, they may be prosecuted by the agency, and there was such a case which went all the way to the court, and the court ruled that the person was a self-employed person. But on the other hand, the LD did not follow up with that. Now, for FDH, you can say that they do not understand Hong Kong law, but for local agencies to collect such intermediary fees but exploit Hong Kong local labor, the LD is doing nothing. And another area is mainland workers imported into Hong Kong working in elderly homes. And apart from paying up the intermediary fee on coming to Hong Kong, well, their monthly salary is deducted some 20% or so as a rebate to the employer. Now, all these cases we have reflected to the Labour Department. We have even brought the workers to lodge complaint cases or to take their testimonials, etc. But the LD said insufficient evidence, we're not going to follow up. And the mainland worker had by then gone back to the mainland. Now, if the government is saying that they want to extend the scheme of bringing in mainland workers, then my question is, what is the role of the government? What is the supervisory role of the government? Now, for these elderly homes with the foreign workers, nobody is taking care of them. And the moment they voice their opinion, they are fired. And some of the employers actually bring these workers to non-licensed places to work. And as a result, they get caught and they are imprisoned even. Mr. Chang Ching-fat. Yes. We are concerned that the Hong Kong agencies there have been misrepresentations, seriously violating the laws. Now, especially for elderly homes, there are a lot of agencies. They use a lot of the agencies to bring on workers at these homes. Are these workers really employees? That is dubious, because they are very often presented as self-employed persons, and the employer treat these employees actually as self-employed persons. So I would ask, is the ordinance lagging behind what is happening in the society right now? If the employer is not an agency, for example, it can appear as a register as in another identity under another guise and exploit these workers. Now, apart from foreign workers in Hong Kong, how many agencies actually register as intermediaries or agencies? And what kind of businesses and trades are these agencies involved in? I would like to see data and statistics. Then you will know why we say that the ordinance is lagging behind. Now, concerning overcharging by agencies, yes, these agencies are overcharging because they collect not only one time of fees, but actually they get a cut of the pay to the worker on a daily basis or a monthly basis. So there are all these violations in the labor market as we see it today. Perhaps the government can give us more information today so that we can have a more realistic view of the situation.
Thank you. I'm a principal lecturer at the University of Hong Kong and a specialist in employment-related matters, especially as the employment industry, agency industry in Hong Kong. And I would like to note that there's a consistent theme that keeps on happening as people are primarily focusing on enforcement of regulations. And that's really what I'm focusing on today as well. First, I'd like to support and really applaud the EAA and the Labor Department in terms of bringing forward the Code of Practice and advancing, hopefully, some of the punishments against employment agencies. But what I would like to point out is that based on my professional opinion, the amended employment ordinance as drafted and the Code of Practice are largely unenforceable unless we also take measures to extend the ability to enforce those provisions. The key obstacle to enforcement of the Code of Practice and the proposed amendment to the EO is simple. It's time. It's time. Currently, almost every claim against an employment agency has to be lodged within 6 months from the date of the offense. That is unusually short when compared to other Hong Kong laws. And the Labor Department and the EAA have admitted many times that their primary restriction and limitation to bringing claims against employment agencies is the fact that they don't have sufficient time to prosecute those claims. In fact, most of the claims that we see through all the different NGOs and organizations that work with domestic workers and employers, their number one problem is they actually are time barred and don't have the ability to bring those claims. Now, again, as everyone has pointed out, enforcement has always been the issue. It wasn't that the penalties were too low, although I'm very happy to see the penalties are being increased. The issue has been enforcement. And the proposed amendment to the EO does increase penalties, but doesn't really address how to enforce those new higher penalties. This is very easy to solve. That's the good news. We need to add a time limit to the amended employment ordinance to increase the amount of time whereby people can bring claims against unscrupulous and illegally acting agencies. This will give the EAA and the Labor Department the time that they need to bring claims against agencies. This is not controversial, and it is standard if you compare it to other laws in Hong Kong. Indeed, when surveyed, over 70% of people in Hong Kong have stressed that they would like to see greater regulation against employment agencies. This is not only what Hong Kong people need, but it is also what they are asking for. And again, as my role as a professor at the University of Hong Kong, I have asked several barristers and professors about this particular amendment, and unanimously, everyone has agreed that the draft is ambiguous and would create confusion and would be almost unenforceable as drafted unless we address the time limit issue. Thank you.
Thank you very much. Mrs. Parachat.
Good morning, Mr. Chair and everybody here. Now, today I present as a representative of Hong Kong Federation of Asian Domestic Workers Union. We have Thai, Nepal, Philippines, local to be the member of Federation. We welcome the bill of the amendment of COP on regulation employment agency in the employment agency regulation and the employment ordinance EA. The union welcomes the decision made by the government to raise the maximum penalty for the offense of overcharging job seeker by the employment agency, which is in line with the long-standing recommendation by this union and civil society organization. The union is satisfied with most aspects of the bill. However, there is an urgent need to the Hong Kong government to put in this piece more detail, make sure the taken the high number of illegal employment agencies operating with impunity in Hong Kong. Moreover, the bill does not examine the length of the prosecution periods for overcharging offense. With this concern in mind, the union would like to recommend the following. It is widely known that the employment agency collecting illegal agency fee. The Article 4.12 of the Cost of Practice for the employment agency state that the employment company should avoid involvement in financial affairs with the job seeker, but the bill does not provide relevant provisions. We recommend adding Article 4.12 to the bill is penalties which are commensurate for the offense In this way, the COP and the bill will work in tandem to put an end the illegal placement fee. So it means maybe COP just prosecute only lost the license of the agency, but not put in. If you not put in the bin, is the prosecution is not make the agency afraid of the COP, so maybe they not follow the COP. Also, we want the COP is no limit time for periods of prosecution or indicates offense if the prosecution period must be 2 years. And then we want to increase more penalty of the keep the important document of the migrant domestic workers. And also we want you to put the criminal of the underpay for the employment, because we have the survey the last year about the Nepali workers is many they facing the underpay from the employer. Also, we need increase the manpower of monitoring about the COP for the Hong Kong government. Thank you.
Next, we have Mr. Tan Kin-wah. Chairman, you and we are very familiar with this. When we talk about labor protection, the government is not doing enough, obviously. For this amendment bill, is like a drug prescription. Well, it just goes to the part of the throat and the esophagus, and it doesn't get into our digestive system, then it doesn't suffice. So, of course, we welcome the certain parts of the bill, especially increasing penalty for overcharging, and we welcome that. And that is made in response to our demand earlier. But then, we have to take a more macro perspective here. Now, for Hong Kong's population policy, we said that by 2064, there will be some 600,000 foreign domestic workers in Hong Kong, and the policy address said that there will be more imported labor, and they are going to be imported through EAs. So will the government come up with another population projection or another projection in relation to the enforcement manpower within the Labor Department? The government has been pursuing to import labor from South Asian countries, from Cambodia, Vietnam. So will you be having another projection, and that is by 2064, what kind of manpower do you expect to have at the Labor Department to deal with the problem? Now, we've got some 300,000 domestic workers here in Hong Kong, and there is so big a problem of overcharging, and the government has admitted that there is a lot of problem. So that's why they've come to this stage that they are amending this employment ordinance. But are you going to increase manpower to supervise the EAs? This presents a big challenge to you. And also, on the detailed content of the bill, we have certain comments. Say, for example, in the Code of Practice 4.12, the EAs are asked not to interfere with the financial matters of the job seekers. This is a very important point, because in many cases, we see that the EAs are colluding with the financial companies to exploit the domestic workers. We think that this paragraph 4.12 should actually categorically be included in the bill and criminalize it. And in fact, when the government talked about amending the ordinance, they said that they should sever the ties or the collusion between the financial companies and the EAs. And we think that such act should be criminalized. Some other speakers also mentioned about the summary offenses So the prosecution period is just 6 months. This is a very short period. Labor Department officers are finding it hard to take out prosecutions. We made complaints to them, and they said that the time has lapsed and they can't deal with it. We've got all the evidence. So can that be turned into indictable offenses? So that the 6-month time limit be done away with, the government must face up to the problem caused by this time limit. We are not comparing it against the 6-year limit for civil litigations. Well, we are just asking it for it to be broadly comparable to indictable offenses. How come that offenses under labor legislation are always summary offenses? Why is it that the labor rights are subject to this 6-month limit? Oh, your time's up. Next one, Mr. Zhao Lok-hang. On this bill, it is proposed that heavier penalties be imposed on overcharging. We think this is the right direction. But then if we have the right penalty, but then we don't have the right enforcement power, which can protect the victim, then this deterrent will just become empty talk. The EAs are running into really great problems in terms of the exploitation of FDH. I think the government should increase further the penalty for overcharging and malpractices. Second, and on EAs and employees withholding passports of FDH, these should be criminalized. Third, we think that more powers be given to the EAs of labor departments, and they should be given more manpower to avoid the situation where enforcement cannot be done because of manpower shortage. Fourth, we think that the government should come up with policies to support FDH in Hong Kong. We've seen many cases of exploitation of FDH. We count on the FDH to come forth to make complaints, but then they are helpless and they are not giving support and they are under a lot of pressure. These people have come all the way here to Hong Kong to make a living, and they dare not take their employers to court very often. And these FDH are not giving compensation in any prosecution cases. And the employers may be exploiting the domestic workers. And once they find that they will be taken to court, then the employers will sack the domestic workers, and within 2 weeks they can't. If the workers cannot find a new employer, then they have to return to their home country. So that deters them from making complaints. So the government is duty bound to these workers being exploited. We have to give statutory status to these shelters for domestic helpers, and financial subsidy should be given to them as well. And also the domestic workers who make a complaint should be exempt from the 2-week rule. And the government should also, within these 2 weeks, find alternative work for them so that they can stay in Hong Kong and assist with the investigation of the cases. It may mean some taxpayers' money to be spent, but if we are spending so much on elephant projects in Hong Kong, why shouldn't we spend more to protect the underprivileged and the laborers in Hong Kong?
Co-founder and CEO of the Fair Employment Agency. We're a nonprofit employment agency that was started about 3 years ago to try to set a new standard amongst these agencies that we're talking about. In the last 3 years, we have grown to now we've placed over 1,700 workers, and we have 20 full-time staff at our office. And what we've seen is that employers lose when workers are taken advantage of. And we've clearly we're on the brink of setting a new standard for how this industry works. Now, I'm actually very optimistic about the direction that the government is going with this. Hong Kong has some of the best laws in place already as far as the protections of migrant workers. What's lacking is the enforcement. And the Code of Practice does cover some important elements of that enforcement, though there are some areas that we think could improve. The first thing that we would like to focus on is the statute of limitations, as they've mentioned, extending that beyond 6 months, maybe making it several years, so that agencies have to think about the consequences of their decisions today, even in the future. The next thing that we'd recommend is look at how they are inspecting or investigating. Right now, agencies will, or the Employment Agency Administration will show up at your office and they'll ask for a bunch of signatures, right? So they want to see company chops and signatures on all these documents. Now, workers are desperate, and so them being in a desperate situation, they're willing to sign anything. So a signature from a worker saying I didn't pay a fee doesn't actually mean they didn't pay a fee, because they're arriving from their home country, they're desperate and they're scared. Now, what we would recommend is that instead of doing these inspections, the Employment Agency Administration would do investigations. So when agencies have when it's been reported that there's been any sort of mistreatment, abuse, overcharging, they then go to the agency, and instead of saying, show us the files that you want to show us, they work through the database and select the files on their own. They can then take these files and call the workers, contact them, and actually understand what happened in that situation. It'll give us a lot better data, and it'll allow the agency's administration to go after these agencies in a way that they haven't done thus far. Okay. This is a really important problem, and the world is watching us. Since we've started, 15 employment agencies from 15 different countries have contacted us and asked us how our model is working and how they could replicate it in their own country. The answer that we always provide is we have the best rules in Asia right now, and that's one of the things that makes it possible. Now, with increased enforcement, Hong Kong can truly be Asia's leader with this, and it's quite simple. And so what we would invite is anybody, if they want to ask more questions or want to know more about it, we would love to share what we've learned thus far. Thank you.
Thank you very much. Next, we have Ms. Tong Hyo-sin. Thank you very much. I am a community relations officer of Foreign Workers Center. We are a frontline service agency for foreign workers, and we do come across a lot of cases involving malpractice on the part of employment agencies. And in 2016, we also see some 90% of these agencies actually overcharge, and of those, half of them have retained or kept the passports of the foreign workers. And these agencies also have certain malpractice, including misrepresentation. I mean, the 9,000 people that we have interviewed, we have seen that this is a widespread problem, and everybody knows that this is a problem, and the government has therefore increased the penalty in the ordinance. As for us, we welcome this amendment of the ordinance, but we do have other suggestions based on our frontline experience. Now, we have talked about foreign workers. It's very difficult for them to proactively bring a case or a complaint to the fore. The Hong Kong system, whether it is immigration restrictions or the 6 months limit, time limit, all these are very detrimental to the victims. And we know of the case, of course, or cases where employees are facing termination. Once their contract is terminated, there's very little they can do, because these workers can only stay in Hong Kong for a maximum of 2 weeks, and they cannot be working. As well, they will have to fund their own provide their own funding for the extension of the visa. And this is very discouraging for them to bring on labor claims or file any cases against the agency. We have a real case where the employer or the Hong Kong agency provide information to the finance companies for the latter to pursue for repayment of debt. Now, this is definitely collusion, and we would want the government to show determination in combating this kind of cases. and this kind of criminal acts. We have some suggestions. First of all, the police department, the labor department, or there should be a cross-department entity which will see to it that this is done. And also to criminalize agencies' behavior, and also provide a better environment for foreign workers.
Director of Help for Domestic Workers, an organization that provides paralegal assistance and advice to domestic workers in Hong Kong. I echo the others in commending this latest effort of the Labor Department in introducing the amendment bill to address the issues of exploitation of domestic workers by employment agencies. But we just wish to clarify some of the issues and make further recommendation to further strengthen the bill. We note the increase in complaints against employment agencies from 44 in 2012 to 529 in 2016, and we say this is only the tip of the iceberg. We receive numerous complaints against employment agencies, but most of them cannot be pursued because, as the others have said, they are time barred because of the 6 months limitation. Just to give you an example, probably very few of you would know that there are Madagascan domestic workers in Hong Kong. 20 of them came to our office to file complaints against one particular agency that brought them to Hong Kong because there's only one agency accredited to recruit them. All of them were charged 24,000 Hong Kong dollars. All their passports were taken by this agency and retained, and they were forced to pay over 80% of their salary each month to the agency. Some of them pursued claims at the Small Claims Tribunal. A number of them were terminated as a result. Those who pursued claims, the agency invited a money lender to provide bogus loan agreements, alleging that the domestic workers have entered into loan agreements. And so, part of our recommendation is to make money lenders liable to prosecution for colluding with employment agencies in exploiting domestic workers and covering up the illegal collection of agency fees. As others have mentioned, because of the summary nature of the offense, the time limitation is just, most of these cases of the Madagascan domestic workers are time barred. So, the agency is still operating, and this creates a culture of impunity among employment agencies. Another thing is, for some of those who have complained while they're still employed, they're not allowed by their employers to attend the office of the EAA to give a statement, and therefore the investigations are hampered. So we advise, or we would recommend that the employers be required to allow domestic workers to attend or provide statements, or go out during weekdays to attend the EAA to give a statement. And if there are dismissed as a result, make that dismissal unlawful as part of the protection under the employment ordinance, like other offenses. Also, there should be greater coordination between the Immigration Department and the Labor Department, so that those who have legitimate complaints would be allowed to stay and take up employment and be, as others have mentioned, not subject to the 14 days limitation. 14 days stay. And those employers who aid and abet the agencies in collection of employment fees should also be prosecuted. And greater effort has to be taken to educate them about the illegality of about the maximum fees that agencies can charge and legality of collection of excessive fees. Thank you.
好，唔該。跟住係 Miss Catherine。
Hello everyone， 咁大家好，我哋係 Safe， 我哋係。
Thank you. We are the Students Against Fees and Exploitation. Now, we are proposing that we have to protect our foreign employees. They do not enjoy a very high status in Hong Kong at present. In our survey, we see that 70% of the agencies involving foreign workers are mischarging, and it is some 13 times over the overcharging it is as bad as that. And also they retain and keep the passports of the foreign workers and also illegally collude with financing agencies in providing finances to the foreign workers. There are a lot of these this kind of behavior. Now, the Labor Department had investigated some 1,300 cases, and some of the agencies, well, actually only 5 of the agencies saw their licenses suspended. And this is very disappointing because foreign workers, especially foreign domestic helpers, are very important for Hong Kong and for Hong Kong families. And in order to combat this black market and the misbehaving agencies, we want to see this amendment of the employment bill to be more powerful. First of all, for instance, the 6 months is insufficient for bringing cases by the foreign workers. And secondly, the Labor Department should be given more teeth to prosecute relevant agencies and to enhance their manpower and also to do spot and site investigations. Without these, even if we increase the penalty, it will not be sufficient because the departments will have to be given the teeth to enforce the ordinance. And also we want to protect the foreign workers who are working in Hong Kong. Through these policies, we want to be able to do that, but there must be effective enforcement before we can achieve that end. Thank you. Now, there are 16 organizations who are supposed to come to this session. 14 are with us today. Now, before there is response from the government, I have a question for Ms. Tong Hu-yan. Now, you mentioned 90% are mischarging and many of them are retaining passports. What is your base number? 5,300 cases. I was referring to the 5,300 cases that we have come across. All right. Would the government want to respond to the questions? Yes. Ms. Wong Ting-chi of the Labor Department, please. Well, thank you very much for coming to this session. Thank you for your views. I'm very happy to note that most of the participants here are in support of this amendment for the employment bill to strengthen the penalties for mischarging or overcharging. That is the main import of this round of amendment, and we are extending the penalty to other persons, that is other than licensees, and to maximize on the penalty. I have heard a lot of views concerning overcharging by agencies, and you all think that this is not acceptable, and this is the main import, as I've mentioned, in this round of amendment, and that is good. I've heard other views as well. For instance, a 2-week stay and also the trial period or probation period. Now, this pertains to foreign workers' policy on the whole, and it may not be most directly relevant to this round of amendment. Perhaps we will be dealing with those issues in the next round. Now, concerning trafficking, human trafficking, from the government's point of view, human trafficking is something that we have been very conscious about, and we have been trying to uphold the rights of foreign workers in Hong Kong. We have to maintain Hong Kong as an attractive place for foreign workers.
So we'll continue with our work on protecting the rights of foreign domestic helpers. Now, there have been many who said something about the time bar for prosecution. Going by our experience, the greatest difficulty is that we don't have a witness, especially for cases involving FDH. It is important that we have evidence from the FDH concerned. And also in relation to licensee, in our current legislation, we can only take the licensee to court in cases of overcharging. But in our amendment exercise, we want to extend the scope to cover directors of EAs and staff of EAs. If they overcharge FDH, they are subject to prosecution. We want to enhance our deterrent effect and can better crack down on illegal acts. We've considered the issue of 6-month bar, whether we should extend it. Well, if the evidence of the witness is most crucial, the longer the time, the harder it is for the witness to recall what happened. And it might not help with the prosecution in that case. So what we're dealing with now, first and foremost, is to increase the penalty and extend it to cover people other than the licensee. So we hope that that can serve as a better deterrent and prove to be effective. There have been some other views saying that the EAs withholding the passports of the domestic helpers. You know that we issued the COP in January stating categorically if the withholding of the passports of the domestic workers without the consent of the worker concerned, then that's a breach under the theft ordinance. And if there is such a case, we will investigate, and we might even revoke the license if the case is substantiated. And in fact, in this year, we had this company, employment agency, and without a reasonable justification, it withheld the job seekers' passport, and it has breached the code of practice, and he's found to be not a fit and proper person to be a licensee. So we've revoked his license. So that's what we've done. And also under the amendment exercise, we've also tried to provide a legal basis for the COP. That is to say, if an EA contravenes the COP, and if the amendment is passed, then the Labour Department will be given more power to revoke the license of EAs breaking or contravening the COP, Code of Practice. There have been some views about protection for employers, consumer rights, and whether the trade description ordinance should apply to the job seekers. In the COP, paragraph 3.8.1, we said that EAs in their operation should not engage in malpractices as stipulated in the Trade Descriptions Ordinance. And the TDO, the Trade Descriptions Ordinance, is about regulating malpractices of service providers. So this applies to the EAs as well. And in our code of practice, in order to protect employers' rights, we said that the EAs should come up with a service agreement and also provide a receipt. And we are also doing the same for the job seekers. In Appendix 2A of the Code of Practice, we have provided a sample of the service agreement for reference by the job seekers. And it states clearly the fee that should be charged by EAs. And also in Appendix 4A, we have also a sample of another document. We would like to help the job seekers as much as we can. And if the job seekers have a receipt, then it will serve as a good piece of information in case there is a complaint. And it's better for the Labour Department to follow up if there is a receipt. And starting from 2014, we have strengthened inspections, and we kept on reviewing the manpower situation. If needed, we will seek for more manpower resources in order to strengthen our crackdown on illegal EAs. The last point that I would like to make is that I've heard views about complaint channels. You said that the domestic workers may not be able to come in person to the EA of Labour Department to lodge a complaint. In fact, what they can do is they can send in their complaint in writing, and then the EA staff will make an appointment with the complainant and ask them to come up to collect evidence from them. We will try to do our best. We will try to come up with an appropriate time that is convenient to the FDH. Thank you. So I'll now open the floor to questions to be raised by our members. 5 members or 6 fellow members have raised their hands. So let me look at the schedule. We started the meeting at 10:45, so each will be given 5 minutes, questions and answers included. Let me read out the names. Poon Xiaoping, Jeremy Tam, Wang Ting-Kwong, Dennis Kwok, Fernando Zhang, and Andrew Wen. Mr. Poon Xiaoping first. Thank you, Chairman. I'd like to thank the deputations for coming to give us your views. I think from so far, what I've heard, you are generally supportive of the amendment of the ordinance. Now, in relation to the overcharging of EAs, we are proposing increasing the penalty. I think that should serve as a greater deterrent. But then the deputations have said that there are 2 things which should be dealt with further by the administration. Well, first is the prosecution period, 6 months. Some deputations said that, 6 months is not good enough, but then the administration talks about the witness and the memory and so on. Now, administration, after having heard the deputation's views, would you reconsider the prosecution period? Well, some asked for 2 years. I don't know whether it's the most appropriate period, but please consider their views afresh. Also, manpower, as mentioned by some deputations. I won't repeat the points made earlier by deputations. I'm rather more interested in about the point made by the Trade Union of Community and Institutional Carers about local elderly homes. Now, local EAs will bring in workers for elderly homes in Hong Kong, and they are considered as these workers as self-employed persons. I would like to ask, how many complaints have you received in the past and referred the cases to the LD, and then prosecution couldn't be taken out? I know there are 3,000 EAs in Hong Kong, and some 1,000 of them work on FDH. But then what about the local, elderly homes? Have you got any statistics on that? The Labour Department, please. Mr. Poon, about the statutory prosecution period. We will consider it further. But then the main purpose of this amendment exercise is to enhance the deterrent effect of the penalty on overcharging. So that's why we increase the penalty and then extend the offences to cover people other than the licensee. So this is the major purpose of the amendment. Now, going by our enforcement experience, it really depends on whether the person or the complainant involved is willing to come out to give evidence. And then we are also impeded by the fact that some people said that they are not involved in the overcharging. So that's why we are working on those aspects first in the current amendment exercise. Now, about bogus self-employed people. Now, in the definition of EA, it means that the EAs are people who secure employment for some workers. So only when that definition is met will it be coming under the ambit of the ordinance. Now, if some service provider takes on a person and then sends somebody to work in a certain place, and that this service provider may not come within the definition of EAs in Hong Kong, we don't have any statistics on whether there are service providers or the number of service providers in Hong Kong. So we just have breakdowns on EAs which work on local placement, local workers placement, or overseas workers placement. Well, the complaints are not substantiated because mainly you cannot establish an employment relationship there, right? That's why you wouldn't be able to follow up. Yes, if they don't come under the definition of EAs, and we can't do anything about them, even if there is overcharging. Ms. Zhang referred to some of the issues, and maybe the other sections of the Labour Department will take those issues up. Mr. Jeremy Tam. Thank you, Chairman. I would like to ask something about the code of practice. You cited an example. Say, if they withhold the ID card, this agency was license was revoked by you. That was this case you mentioned. Does it mean that the greatest penalty is that the license will be revoked? In COP 4.1.2, it says that the EA should not be involved in the financial matters of the job seekers. Now, the greatest problem is that the migrant workers are asked to take out a loan to pay for the placement cost, and also for the placement cost charged by their source countries, EAs. So if you are just putting it in the code of practice, the most that you can do when there is a breach, that the license will be taken away, and there is no other penalty. Well, that won't suffice, I think, in my view. Well, there are two routes that we can take, I would say. In the code of practice, the EAs should not be involved to the financial matters of the domestic works. In other words, they cannot take the migrant workers and financial company to take out a loan. If they do that, their license will be revoked. Now, another scenario is that the EAs will take the money from the financial company as the placement cost. Well, in that scenario, we would really investigate into that, and we'll look at whether there is sufficient evidence to follow up further. Whenever we receive a complaint from the migrant worker, they would always tell us that the EAs have charged them, say, $1,000 or $2,000, then we will embark on a criminal investigation on overcharging. And then if we find out further that the migrant workers are taking a loan from the financial company, then we will look at whether the COP has been breached, and the financial company will also be taken to task as well. Now, the EAs will ask the migrant workers to take out a loan from the financial company, right? Now, what I'm worried is that the EAs in the source country will overcharge. They will charge the portion that is due to be paid to the Hong Kong EA first, and then the overseas EA will share this overcharge fee with the local EA later on. So this may be a loophole. Now, regarding 4.1.2, maybe you can make part of the law so that this loophole can be plugged. The scenario that I mentioned, that there's overcharging, they're shifting the overcharging to the source country, will be avoided. I understand what your concern. Hong Kong's jurisdiction is just is that we can have power over only local EAs now. But Mr. Jeremy Tam mentioned that before the migrant worker comes to Hong Kong, then they are asked to pay a high placement cost overseas. No. I'm not talking about before they come to Hong Kong. After they've come to Hong Kong, they are still being asked to take out a loan at a local financial company, and they are asked to pay that placement cost to the EA in the source country, and then the EA in the source country will split the money together with the local EA.
And it's not even in the Hong Kong jurisdiction. No, so I can think of this as a loophole. Now, in the existing ordinance, you can only revoke the license. Isn't that so? Well, we can go back and see whether we can plug this loophole. But if I can just respond briefly, if the fee is collected in Hong Kong, then we can already prosecute for overcharging. But if you're talking about an overseas entity providing the financing, then we will have to look at the... No. I'm talking about a situation where, let's say in Indonesia, I have already set up a company to provide service locally in Indonesia to this agency. It's a left pocket, right pocket situation. Well noted. We will go back and consider this. Well, yes, actually quite a few members are concerned about the loophole that you have mentioned. But on the other hand, our ordinance basically is limited by the within the Hong Kong jurisdiction. And that's why I'm talking about the code of practice. Well, I actually should not be interjecting, but if all FDH can borrow money in Hong Kong and need not pay back, then that may be problematic in itself as well. Hon Kwang? Well, first of all, thank you for coming up to the LegCo here. Now, today, we see that a lot of you are supportive of the Employment Amendment Bill in principle. However, we often see that with one solution comes another problem. The Hong Kong FDH, the Foreign Domestic Helper, situation is already a cross-national issue, and problems are really cross-national as well. Now, Mr. Tam had talked to the following, and that is, if the criminal individuals or groups in Hong Kong are colluding with overseas groups and individuals, that is really beyond us. And what do we do? The government departments really have to think through this carefully. Now, drug trafficking. Why are we able to combat drug trafficking and not, for instance, these foreign workers? Why are we so helpless when it comes to foreign workers? I mean, we have been combating international criminal groups as well. We have solutions there as well. So I would urge the government to utilize your wisdom and be able to provide the solutions. If you are just focusing on our local jurisdiction, our local agencies, and not be able to reach these outside entities, you'll never be able to plug the loophole. You will have to face up to this task. And secondly, I think publicity in education is also important. Of course, so many people come to Hong Kong as foreign domestic helpers, traveling all these thousands of miles. It is because they're seeking a better livelihood. That is the reason. You think about the Chinese laborers 100 years ago traveling to overseas, far-off overseas countries. Think of the exploitation. It's really very pathetic. So you must step up with publicity and education so that these workers know if they come to Hong Kong to work, they will not be exploited. And if there are such cases, we will provide the environment and the measures for those cases to be corrected. So this has to be an international mechanism as well for publicity in education. The SAR government must think of that. Well, thank you, Mr. Wong. We are definitely working very hard towards this end. For publicity and education, we have been continually coming up with new programs and measures to educate employers as well as foreign helpers. We understand that they have traveled 1,000 miles to Hong Kong and they need a lot of help and support. Now, last year, we have come up with a consultation stop with or center with the local languages, Indonesian and Filipino, and working with the respective consulates to tell these employees what some of their rights and protections. If we have more manpower, we will strengthen this area of work. We will continue to do so. We put in a lot of efforts in making Hong Kong as an attractive place to work for foreign domestic helpers. We understand that they're important in taking care of Hong Kong families, the young, the elderly, and they are a very important part of our workforce. Yes, we will continue to do so. Internationally, we have been working together with the Philippines and Indonesian government departments and their consulates in Hong Kong. We have been communicating with them in various regards. First of all, before they arrive in Hong Kong, how do we lessen the burden, financial burden for them? The head of the department went to Cambodia recently, and because we have newly imported Cambodian workers to Hong Kong. And he's also mentioned how the financial burden can be minimized for Cambodian helpers so that they are not exploited by employment agencies. Mr. Wong? Now, one of the deputations mentioned that we should have a score system for the employment or local employment agencies. Can you consider also the foreign employment agencies as well? Can we have a publication system or open shame system where these misbehaving or delinquent foreign employment agencies, can we expose them and also refuse their referrals? Well, actually, you have exceeded your time and you're asking another fresh question. Yes, the government will answer that question after this round. Mr. Kwok Wing Hung, please. Now, Mr. Wong asked a question concerning not able to reach outside of our jurisdiction, where there are criminal activities outside of our jurisdiction. Well, there's not much you can do, and you cannot achieve anything with this amendment, I'm sure. But it doesn't mean that the Hong Kong government cannot or should not consider this. A lot of deputations have mentioned that if Hong Kong does not have a comprehensive human trafficking law or forced labor-related law, as in the UK there is this Modern Slavery Act. If you do not have that, as Mr. Tam Man-ho or Mr. Wong mentioned just now, the issues that they have mentioned is really beyond you. Now, Mr. Wong talked about drug trafficking. Why is the Hong Kong government and the enforcement departments be able to have more measures in combating drug trafficking? It is because there is an international mechanism, a coordinating mechanism. We also have anti-money laundering law for the police department and the enforcement departments to investigate the proceeds from the drug trafficking and other criminal activities. Of course, if you increase the penalty, we welcome that. But on the other hand, if the department does not think of a comprehensive anti-human trafficking law, I think this is just patching things up, and it's not really totally effective. Now, another question concerning the time limitation for bringing prosecution. Can you respond to that question, please? What are your present thinking, please? Thank you, Mr. Kwok, for the questions. First of all, for the prosecution period, we follow the magistrate's ordinance, and that is the codified law number 26, and that is a prosecution time limit is 6 months. Now, according to the amendment law, Section 60 concerning overcharging, it is exactly falling within this ambit. And in our present round of amendment, we have not recommended a change to this because we would want to, on the basis of this ordinance, combat overcharging. And from our enforcement experience, we see that it is often the case that the licensee claim that they do not know that the staff is overcharging, and therefore they go scotch-free. Well, I understand about the 6 months, but now you are making the penalty heftier. I also hear that I also hear from frontline workers and NGO with experience that they say that a lot of cases exceed the 6 months, and therefore they're not able to bring the prosecution to the fore. So my question is this 6 months really applicable, this criminal, for bringing criminal prosecution? I think 6 months just too short. You should consider lengthening that. Well, I hear your view. We've heard views saying that the case may extend to beyond the 6 months. Well, I think in our publicity, we have, through the NGOs and through our own publications, made it known to the foreign helpers, and we want them to come forth to us as early as possible. This 6 months period, once we have received a complaint, we will try to complete all our work within the 6 months, even if it means overtime work for our colleagues. They do not mind that. They try to complete it, the cases within 6 months. I know you're hardworking, and it's not about working overtime, but this 6 months is not really it can be extended, the 6 months. I'm sure it will not hurt the ordinance in its enforcement, but rather it would help. And I'm sure that all the parties are in support of this as well. And therefore, please, I urge you to go back and think about extending this 6 month requirement. Yes, we will do so. Next, Fernando Zhang. Thank you very much, and thank you for deputations for coming up to talk to us about the problems. Now, I heard Mr. Wong, Ting Kwong, just now. He spoke so earnestly and so sincerely about combating exploitation. I salute that. I very seldom praise the pro-establishment camp, but I see today that from his eyes, I see that he is sincere, and that is commendable. I've been many years a social worker, and I don't see a lot of sincerity on their part, and I therefore find this very valuable. I think you're being very courteous and polite. You are praising the government for coming up with this amendment and the code of practice, etc. But for foreign workers, the overall situation is vexing. For the longest years, we have been exploiting them, allowing agencies to mischarge, overcharge, forcing them to take out loan shark financing and colluding with the loan sharks, and it's become really forced labor. retaining their passports and having to leave within 2 weeks of termination. It's just not fair.
But then you are being very nice and courteous. And Mr. Wang Tingguang was right in pointing out that as our government has all the power and can do whatever it likes. But then you told us that this is cross-jurisdictional crimes and there is nothing that we can do. But we have a consensus here, whether it's coming from the legislators or the deputations. This 6-month prosecution period is an unnecessary restriction. And because of this restriction, a lot of the cases are not being dealt with because there wasn't enough time to collect the evidence. Today, do we have someone from the Department of Justice here? So for this amendment bill, can the government move a committee stage amendment? Is there any difficulty of doing it? So is there any difficulty of making this an indictable offense? Is there any difficulty of doing that? Mr. Zhang, well, let me respond to this. We've had views from deputations and legislators on the prosecution period. You hope that the government can consider lengthening that period. We will study into that when we go back. Well, that's all I can say today. We will go back and take a look, definitely. Yes, please do so. Well, please follow the good advice that we've given you. And some deputations refer to some EAs putting in place bogus self-employment, and they are charging much higher than the 10% prescribed in their commission. The assistant commissioner looked surprised when she heard this, but in August last year, some deputations have protested outside the Employment Agency's administration of LD, and they mentioned this company, Batbon in Chinese, commonly used by the NGOs. And I think the situation is very rampant, whether we're talking about private residential care homes for the elderly, subsidized homes for the elderly. They count very much on these intermediaries to refer care workers for them, and also professional staff such as nurses. And I'm sure they are charging much more than 10%, sometimes as high as 20%. And some of them haven't taken out labor insurance for their staff even. And the staff have to be responsible for their own safety at work. I wonder how come that you haven't received reports and news about this being the case in Hong Kong. And how rampant is the situation? Maybe you cannot give me an answer today. Maybe after the meeting, provide us with further information. Try to respond to points raised by Mr. Cheng Ching-fat and also Madam Zheng, the questions they raise. Please do that. Yes. Mr. Andrew Wen. Thank you. Chairman. My colleagues have asked so many questions. I will not repeat those. I've raised one which has not been mentioned by others. Mr. Jeremy Tam and other members have referred to asking workers to take out loans with financial companies. So please study into that. I'm also concerned about the technical side, whether that situation can be dealt with, and also the prosecution periods and so on. Anyway, I'm going to ask another question here. Well, there are 17 officers in the EAA, right? Now, if the bill is going to be passed, I'm sure that workload will increase. Now, you have to handle 1,400 EAs, which means one officer will have to deal with some 80 EAs. Would you be adjusting the ratio so that you can enforce the amended law better in the future? Thank you. We will continue to review our manpower after the bill is passed. Our workload will rise because we are covering more aspects. So we need to do more investigation. We will review the situation. Do you have any projection on the increased manpower? We would try to strive for more or seek more resources from the central authorities. We launched the COP early this year. And actually, we spent more time on inspections because we have to look at more aspects of the EAs. And we will see how the situation goes. And if needed, we would definitely increase more staff members. And the ultimate aim is to crack down on the malpractices of EAs. We want to achieve that. Let me ask one thing more. We are talking about the prosecution period, and also we want to include the offenses as indictable offenses, and I'm sure that we will follow up on those aspects. There is one more thing on the COP, retaining the passports, withholding the passports of the domestic workers. This is now governed under the COP. Is it possible to make that an offense without the workers' consent? If the employer or EA are holding up or withholding the passports, that is already an offense. And in the COP, we're just adding in one more thing, and that is their license will be revoked if that happens. And if we receive such complaints, we will refer the cases to the police for further criminal investigation. Why did I ask this, Chairman? Because in earlier discussions, we said that the EAs often have better ways to outsmart you. The EAs have various excuses to justify their actions. They actually even ask or force the domestic workers to sign a letter of consent that their passports be kept at the EAs. So these are the tricks employed by EAs. So if we don't make that a very grave penalty, then I think it won't be effective. The situation wouldn't improve too much. We should impose more severe measures. I understand your point. We will continue to talk to the police to see how things can be improved. On our part, we are doing it by the weight of COP for the moment. I suspect that even if we have it written into the law, then the EAs will still do the same. They will say that they have already obtained the consent of the domestic workers before they keep their passports. So according to what you said, the COP doesn't work at all, right? It's ineffective. Well, in actual fact, we have revoked the license of one EA. But when we talk about criminal investigation prosecution, the proof of standard is beyond reasonable doubt. And the Commission for Labour is now given the power to exercise discretion, and the yardstick of the Commissioner is a bit different from that of criminal investigation. All right, it's my turn to ask questions. Members have been very good at raising very good questions. There are several aspects that I would like to say. Deputations have expressed clearly that they want the government to strengthen enforcement. They ask for more manpower to enforce the law, to step up your inspections. Second, the deputations have said that they don't have major objection to the amendments. They even said that they support them. But then it won't eradicate the problem. There are still a lot of flaws and deficiencies, and the administration should consider patching up those. Well, please respond to the points made by the deputations as soon as possible. Ms. Zhang reminded us that this bill should not be just targeting EAs working on FDH. It should target all EAs in Hong Kong. So when elderly homes bring in foreign or migrant workers, they serve two roles. They are both the EAs and they are also the employer. They exploit the people they bring in. So you have to address this problem. They shouldn't be allowed to make use of the loophole in the law now. They are now playing a dual role here. For those who overcharge or breaching the COP, you said their licenses will be revoked. The Labor Department may consider it as a sort of the maximum penalty, a very heavy penalty already. But then deputations say that if they are a crime syndicate, they may open up EA one after another if some of them are closed down and they are bringing in different people to set up the EAs, and that's going to be a problem. So which means that revocation of license should not be considered as the maximum penalty. You should consider even further penalties. And you think revocation of license is already good enough, but then the EAs can still outsmart you, and they can set up another EA all the time, and people have lost confidence in the law as a whole. As Assistant Commissioner, we want to achieve our policy objective in this amendment exercise. Some deputations question the effectiveness of the COP. We want to prove that the COP is really effective. As to the question of penalty, we will continue to work on that. The chairman asked whether a licensee who has been whose license has been revoked, can he ask somebody else to be the licensee, and then they can set up another EA? Well, the law, our amendment, is now dealing with that already. The commissioner can take into more factors now under the amendment to consider whether to issue a license. If a staff member of the EA does something wrong and the license has been revoked, then the commissioner can consider not refusing to grant another license. Now, for the elderly homes, which are playing a dual role, and they are subject to Section 12 of the Employment Ordinance. In cracking down on bogus self-employment, the Labor Department has been doing a lot of public education promotion work. And we've been educating the employees on their own rights. And our inspection team, our inspectors actually, conduct visits to elderly homes to see whether such misbehavior is happening to crack down on bogus self-employment. We are adopting a two-pronged approach here. So if a worker or an employee suspects that he is being exploited, he can come to lodge a complaint with the LD anytime, and our staff will provide advice to them. We will definitely do that. Next, we have Dr. Elizabeth Quat, 5 minutes. Thank you, Chairman. I'd like to thank the deputations for coming. Dr. Fernando Zhang, while he's left, I would like to respond to what he said. Dr. Zhang, if they cast aside their prejudices, then they will be able to see clearly that the pro-establishment camp members are working very hard to improve the lives of Hong Kong people, and they just misunderstand what we said this time. The pro-establishment members, like Mr. Wong and myself, we understand that that the exploitation of the FDH is here with us, has been here with us for a long time, and we support the amendment exercise.
And Mr. Wong had talked to the importance of publicity and education, and you have responded that you have done some work in that regard, including in the countries concerned, together with the consulates. But is it sufficient? Because we do know of illegal agencies and organizations which attract people to come to Hong Kong, but actually swindle them and overcharge them. They have abused the Hong Kong system, and people have fallen victims to their malpractice. Now, for this kind of education work, we've gone to these countries locally to do the publicity work, and I believe in the past 1 year there are less of these malpractice cases or abuse cases, and I think we should leave more resources to help with these the people aggrieved in these cases. Now my question is, these employees and these FDH, why are we not able to be more effective in providing education and publicity in their hometowns, in their home countries, before they come to Hong Kong? I want to know how much you have done so far, and whether you will review your practice and look at experience from other departments to see what you can learn from them, because prevention is always better than redress, isn't it so? Thank you, Dr. Kwok, for the question. In fact, we have always been providing publicity in the home countries of the FDH through their agencies and the organizations, so that they know what are their rights when they come to Hong Kong. And our consultation center for FDH is exactly set up for that purpose. The website actually is available anytime, anywhere, and we provide the local languages, Thai, Tagalog, and also Indonesian, so that the FDH, before they come to Hong Kong, they will have that information. We also think of other ways where we can effectively disseminate the messages we want to disseminate to employers as well as the FDH, both locally as well as overseas. But of course, we will need the resources to do so. Mr. Chair, the government mentioned that they are relying on the agencies or intermediaries in playing a video or providing the website information to the prospective FDH. I mean, if they already have the intention of exploiting these workers, they would not be doing that for you. So have you been talking to the NGOs whether there are better ways to reach out? And that is to reach out to prospective FDH before they arrive in Hong Kong, or perhaps provide more publicity within their circles here, rather than to rely on the intermediaries or agencies? Yes, perhaps I should put the question to you all. Do you know of ways for the government to better provide the education? Now, the rights education campaign mounted by the government, the administration was saying that they are going through the consulates, the Philippines and the Indonesian consulates, and the Labor Department is working together with them. But what about the other consulates? I don't think we should even go through the consulates, because they can choose to do it or not to do it. What about the Cambodians? And what about the Indonesians? And what about the Nepalese? and exploitation there is also very serious. And also, for the scheme for foreign laborers, the government is taking proactive action. Why not for FDH? And that is for the supplementary labor scheme. Well, yes, I think even before they arrive in Hong Kong, they should be educated that their passports should not be withheld from them, that they should not be overcharged, and this is not right, that we will not accept this in Hong Kong. And also, the 6 months is a problem, as many have talked about. Can you respond to us in the next meeting? Administration. Right. Yes, the time is up. No, I was saying that consulates, if they do not cooperate, what can you do? Mr. Chairman, if I may supplement, the supplemental labor scheme is where the government provides proactively seminars, talking directly, educating directly the supplemental labor. Why is there this difference in handling the FDH? We still have time for discussion, Chair. Well, I will decide whether there is still time. I mean, if the questions are meaningful, yes, the administration will answer the questions. There is no second round of questioning, but I will allow the following question. Ms. Lee? Yes, the 6-month period. Ms. Wong had mentioned just now, it is because of the magistrate's ordinance. That is a basis for the 6-month limitation. But with this amendment, the highest imprisonment term is 3 years. It's been raised to 3 years. And therefore, the district of court will be responsible, not the magistrate's court, and therefore the MO will no longer be applicable. Now, everybody's very concerned about this. Perhaps you can give us a clearer answer with regard to this, rather than to base our discussions on hypotheticals. Now, if it's 2 years or under, it is the magistrate's court. If it is over that, I mean, it would be like in the district court, so it would be more than 6 months allowable. Can you answer that question, please? Mr. Chair. Yes, the 6 months continues to be applicable. Now, the question is, what is the basis? What is the legal basis? The Section 26 of Magistrates' Ordinance, that is the basis, because this is a summary procedure. It is a summary offense, and therefore it continues to be dealt with in the magistrates' court. And delegates, you have to understand that there is no allowance for dialogue between deputations and the administration. You cannot just carry on a dialogue between yourselves, regardless. Yes, the legal department had given you a response. You can be satisfied or not satisfied with the answer, and they will also provide a written response as well. Now, Mr. Tang asked a question concerning the education for the FDH. Why are only a few countries covered and not some other countries? Well, Mr. Chair, I just want to clarify that we also proactively conduct education seminars as well. But having worked with the consulates, we see that it is swifter and more efficient. And that's why we have been working with Indonesian and Philippines consulate and also the Thai consulate. And for the other consulates, yes, in our interviews and meetings with them, we have also told them that we welcome working with them in organizing these briefing sessions for FDH. And going back to Dr. Kwok's question concerning other groups, well, In my past contact with them, I know that there are other bodies which are interested in educating the FDH, and also we will continue to improve on our publicity and education programs. Now, working with experienced organizations is good. Now, we also provide or distribute information packages through the ISF. We distribute these information packets to arriving FDH. We would want to be more effective in providing education and knowledge to the FDH. We do not cease thinking about new ways. Yes, Mr. David Bishop, would you want a second round to speak? Or rather, do you want to raise a question?
A little bit of both. To clarify one of the points that just came up, again, because of my position at the University of Hong Kong as a lawyer and legal scholar in this area, I did reach out to barristers and my colleagues at the University of Hong Kong. And concerning this type of an offense, to have an offense where the maximum potential penalty is 3 years in prison and $350,000, to keep that a summary offense without a specific time limit is extremely unusual. And among all of the legal scholars that I consulted, every one of them said it would cause very significant confusion in terms of how to prosecute and handle those claims, right? Because on the one hand, you have because it does not state indictable offense or upon indictment, therefore it's not an indictable offense. However, because the maximum penalty can go up to 3 years, it would be difficult to understand, should it be a summary offense that is heard in a district court? Should it be treated more as an indictable offense, but then heard by the magistrate's court? It's very, very confusing, even among legal scholars in Hong Kong. And again, highly, highly unusual. And one of the things that has come up multiple times is the Labor Department has stressed that although the time bar is an issue, they keep going back to the fact that they can't get witnesses for these claims, and that's their primary difficulty when prosecuting. First, that's not true, because most of the claims are never even brought to the Labor Department because they're time barred. Right? This is something that all of the NGOs that are represented here, they have thousands of potential claimants every year, and most of their claims never even get brought to the EAA or the Labor Department because these NGOs filter them first, and they say they're time barred, you can't bring this claim. Right? But the second thing is, my question that I would like to understand is, and I've asked this multiple times over the past few years, why do they require such high evidentiary standards to even bring one of these claims or to begin investigation of these claims? I have personally provided the Labor Department and EAA witness testimony and video evidence over the past 2 months of agencies that are exploiting and illegally overcharging domestic workers. And their response has been multiple times, we need to speak to the people, we need to have witness testimony of these things. And so my question is, if you have the ability as the Labor Department to remove the license of an agency that is overcharging, why not remove that license when you receive irrefutable video evidence of this illegal behavior? And I think that's an important question, because there are many, many groups around Hong Kong that are willing to help them and can help them overcome their labor challenges, their manpower challenges, if they would be willing to be more open about the evidence and help receive help from outside organizations. I think every organization represented here today is willing to help them, but it just seems oftentimes it's difficult to provide that help to them.
佐主。
多謝主席。其實頭先Mr. Bishop 提出一個問題，就係關於
Now, Mr. Bishop raised a question concerning the evidence, raising evidence. Now, we all understand that Hong Kong is where there is rule of law. And in bringing up a prosecution, we need sufficient evidence. And whether the evidence was legally obtained, whether it's admissible at court. And the courts have very high standards here in Hong Kong. Of course, we have talked to them saying that the victims
they want to turn everything into a prosecution. What I'm saying is, why not, as the Labor Department, withhold or remove the license without the prosecution? It's within their power.
你可唔可以自己做 judge 啊？
我唔可以，即係我冇受過法律嘅訓練，所以我唔可以。 不過即係喺嗰方面其實。
Well, I myself am not legally trained. Of course, I cannot be the judge, but we would want the victim to provide all the relevant information so that we have sufficient information for us to believe that there is a violation, which may not be the court standard or court level, and we will continue and pursue these cases. Well, thank you very much for coming up today. And I would want the administration to provide a written response to the questions and answers raised today. And if you can provide further information, that would be good. Thank you. Now, members, colleagues, please take note. Our next meeting will be on the 21st of November, 10:45. It is a Tuesday. Please do note. There's another choice, and that is 22nd of November, 8:30 a.m. Would you want to choose the latter? Perhaps not. So, 21st, 10:45. Thank you. Yes, would the department also please note that? Thank you very much again for coming up to the lecture today. Thank you. Meeting closed.